The United States Department of Justice just executed the most humiliating legal reversal in modern political history by throwing in the towel on 4 major court defeats, and then violently yanking that towel back less than 24 hours later. Top prosecutors walked into federal court and admitted absolute defeat regarding the unconstitutional executive orders of the former president meant to punish private law firms. They formally filed to withdraw their appeals. The ink was barely dry on their surrender before panic set in. Orders came crashing down from the very top, forcing those same prosecutors to march back into the courtroom to face the judges and pretend they never asked to quit. It is a stunning display of internal collapse driven entirely by a political faction that refuses to ever admit a loss even when staring at guaranteed destruction in the appellate courts. Simultaneously, an entirely separate embarrassment has just leaked. The same legal apparatus suffocating under extreme pressure from the commander-in-chief to build a criminal case against Joe Biden over the alleged use of an automated signature pen has completely failed. They could not build the case. The absolute inability to weaponize the justice system against political rivals is suddenly exposed for the whole world to witness. The leadership is quite literally circling the drain while trapped between impossible political demands and the immovable reality of the law. Welcome to United States News Daily. We are breaking down the absolute chaos unraveling within the highest levels of the legal system today. If you want to stay ahead of the spin and understand the real legal maneuvers happening behind closed doors, take a moment to subscribe to the channel and turn on the notification bell so we can keep navigating these historic events together. Power grabs rarely look this clumsy in broad daylight. The chief executive weaponized the highest office in the land to settle personal grievances against private attorneys, fundamentally misunderstanding the boundaries of constitutional authority. This was not a subtle policy shift or a standard political maneuvering tactic. It was a direct, transparent threat aimed at the livelihoods of legal professionals, functioning essentially as state-sponsored extortion. The administration decreed that if a private law firm represented a client or championed a cause that offended the personal sensibilities of the president, those lawyers would face draconian, unprecedented punishments. The sheer audacity of the penalties drafted into these executive orders exposed a severe detachment from legal reality. The most cartoonish and blatantly unconstitutional penalty dictated that attorneys from blacklisted firms would be physically barred from setting foot inside federal buildings. That broad ban explicitly included federal courthouses. The executive branch attempted to literally lock defense attorneys out of the very rooms where the Constitution guarantees the right to counsel and a fair trial. It was a ham-handed effort to intimidate the legal profession into absolute submission, demanding that lawyers abandon disfavored clients or face the full, destructive weight of the federal government. 4 law firms refused to bow to the intimidation campaign. Jenner and Block, WilmerHale, Perkins Coie, and Sussman Godfrey did not negotiate, capitulate, or quietly drop their controversial clients to appease the administration. Instead, they sprinted directly into federal court to challenge the extortion. The response from the judiciary was swift and merciless. Judges are lawyers first, and they possess a deep, institutional hatred for politicians attempting to dictate who can and cannot practice law. When the executive branch tried to meddle in the core functions of the legal profession, it alienated the entire bench. Judges appointed by politicians from across the entire ideological spectrum united in their disdain, striking down the executive orders as entirely unlawful and glaringly unconstitutional. Faced with universal defeat at the trial court level, a fleeting moment of rational judgment somehow permeated the upper echelons of the Department of Justice. Career prosecutors and legal strategists analyzed the battlefield and recognized a guaranteed disaster waiting for them at the appellate level. Taking these crushing trial court losses to a higher court would not merely result in another humiliating defeat. It would create binding, inescapable legal precedent that would permanently cripple executive power across that entire jurisdiction. The strategic move was obvious: cut the losses, abandon the fight, and prevent the creation of terrible case law. Key figures within the department, including the third-ranking official and a prominent presidential appointee acting as a deputy associate attorney general, signed off on the retreat. They filed the official paperwork to withdraw their appeals. They waved the white flag, conceding that the administration had absolutely no viable path to victory. For a few brief hours, it appeared that the adults in the room had finally prevailed, prioritizing constitutional reality over political theater. The culture of the current administration does not tolerate tactical retreats. The governing doctrine is absolute defiance, regardless of the consequences. The political base operates on a strict philosophy of never apologizing, never admitting fault, and never backing down. When the news of the withdrawal reached the highest levels of leadership, the rational legal strategy was immediately incinerated. The commander-in-chief, likely infuriated by the sight of political opponents celebrating a victory, demanded an immediate reversal. The mandate from the White House to the Attorney General was absolute: undo the surrender. This internal explosion created a catastrophic ethical and professional crisis for the line prosecutors handling the case. The very same government attorneys who had just assured federal judges that the department was voluntarily dropping the matter were ordered to march back into the courtroom and demand their concession back. They were forced to file a motion to undo the motion they had filed less than 24 hours prior. This is a profound violation of courtroom norms. Once a piece is taken off the legal chessboard, a player is not allowed to simply snatch it back because the boss threw a temper tantrum. The humiliation inflicted upon the prosecutors is difficult to overstate. They must now stand before federal judges, individuals who already harbor deep skepticism toward this administration, and attempt to justify a complete reversal of their own legal reasoning. They cannot tell the truth, which is that a political operative with no legal strategy ordered them to keep fighting a lost cause simply to save face. Instead, they must sacrifice their own professional credibility, looking utterly incompetent and directionless, entirely subjected to the daily whims and erratic emotional states of the president. This chaotic sequence of events completely shatters any remaining illusion of independence or strategic competence within the Department of Justice. It demonstrates a catastrophic failure of leadership, revealing an agency that is no longer guided by the law, but rather held hostage by the fragile ego of the chief executive. The attorneys leading these departments are supposed to act as a buffer between political desires and constitutional boundaries. Yet, the leadership structure crumbled the moment pressure was applied from the Oval Office, proving that the department operates merely as a weaponized extension of the president. By forcing the appeals back into active status, the administration is aggressively cutting off its own nose to spite its face. They have trapped themselves in a doomed legal battle that will inevitably reach the appellate courts, where their unconstitutional executive orders will be dissected and destroyed, thereby cementing the very limitations on presidential power they were initially trying to avoid. It is a masterclass in self-inflicted sabotage, driven by a political ideology that blindly values the appearance of fighting over the strategic necessity of surviving. The sheer reckless incompetence required to orchestrate such a massive, unforced error perfectly encapsulates a legal apparatus in total freefall. The federal law enforcement apparatus was mobilized to investigate a piece of stationary equipment. The commander-in-chief issued a direct mandate to completely destroy his primary political rival based entirely on the utilization of an automated signature machine. The absolute absurdity of this directive cannot be overstated. The executive branch attempted to criminalize a standard bureaucratic instrument that has been a staple of administrative governance for decades. Prosecutors were not asked to untangle a complex web of international corruption or financial deceit. Instead, they were ordered to treat a mechanical desk accessory as the centerpiece of a grand federal conspiracy. The reporting emanating from major national newspapers laid bare the immense internal paralysis gripping the Capitol. The prosecutors stationed in the heart of the district were handed an impossible and legally barren assignment. They spent an untold amount of time and resources attempting to construct a viable legal theory that would satisfy the furious demands echoing from the highest office in the nation. They scoured the statutes and desperately searched for obscure historical precedents to justify an indictment. Yet the legal professionals eventually hit an immovable wall of reality. They completely failed to build the case. The foundational elements required to prove a criminal act simply did not exist. This spectacular failure highlights a profound and growing disconnect within the administration. On one side sits an intensely aggrieved political leader demanding the public humiliation and prosecution of a rival. On the opposing side stand career attorneys who, despite operating under crushing ideological pressure, still require the basic components of a crime before they can present a case to a grand jury. An automated pen does not possess criminal intent. It cannot conspire. The complete inability to manufacture a legitimate scandal out of thin air exposes the absolute limits of weaponizing a federal department. You simply cannot force the justice system to indict a piece of office equipment without collapsing the entire legal framework. The collapse of this specific probe acts as a glaring symptom of a much deeper institutional disease rotting the core of the law enforcement agency. The leadership apparatus is severely compromised and cracking under the strain. Prominent figures leading the legal charge are slowly discovering that personal loyalty to the executive cannot magically rewrite the federal criminal code. When the highest law enforcement agency in the land is reduced to chasing ridiculous phantoms dictated by presidential rage, the entire structure begins to fracture. The failure to deliver this highly desired indictment demonstrates an increasing inability to execute the wildly unhinged political desires of the administration. To fully grasp the foolishness of the endeavor, one must look at the historical context of the device in question. Automated signature devices have been heavily utilized by leaders for generations to manage the overwhelming volume of official correspondence and routine legislation required to run a massive government. Attempting to abruptly criminalize a practice that is thoroughly embedded in the daily operations of the modern executive branch reveals a profound ignorance of basic governance. It represents a desperate witch hunt entirely devoid of a witch. The attorneys tasked with this assignment likely experienced a profound sense of professional embarrassment, as they were forced to interview witnesses and draft complex legal memorandums concerning a robotic arm holding a fountain pen. This specific incident marks a highly critical juncture for the department. The constant stream of demands to prosecute perceived political enemies is thoroughly exhausting the system. There is a finite amount of political capital and institutional credibility available to burn before the entire operation loses its legitimacy. By squandering incredibly valuable prosecutorial resources on an automated signature device, the administration broadcasts its absolute desperation to the world. The loyalists positioned at the top of the department are finding themselves hopelessly trapped in a corner. They must either constantly disappoint an incredibly demanding and angry executive, or completely obliterate their own remaining professional standing by filing frivolous and immediately dismissible charges in federal court. Ultimately, the implosion of the signature machine investigation stands as a monumental testament to the extreme friction between authoritarian political impulses and established democratic institutions. The political machinery relentlessly demanded an indictment. The legal reality adamantly refused to yield. This singular and deeply embarrassing failure illuminates the broader narrative of an administration completely obsessed with retribution but increasingly incapable of manipulating the foundational systems of justice to achieve that retribution. The department is actively fracturing under the unbearable weight of these impossible and legally vacuous directives. To understand the sheer magnitude of this unforced error, one must dive deep into the hidden machinery of the federal judicial system and examine the catastrophic concept of the precedent trap. The architecture of the courts is designed with strict hierarchies, where the consequences of losing amplify exponentially the higher a specific case travels. At the foundational level, the trial courts serve as isolated battlegrounds. When a single federal judge issues a ruling, that decision resolves the specific dispute between the immediate parties involved in that exact courtroom. It holds weight, but its geographical and structural reach is entirely contained. A loss at the trial level is akin to a localized fire. It burns the immediate participants, but it does not spread to the neighboring forests. No other judge in the country is legally obligated to look at that specific trial court ruling and follow its logic. For a sprawling federal government, absorbing a loss at this lower level is a standard cost of doing business. It stings the ego of the administration, but it preserves the overall structural integrity of the institution. The legal landscape transforms entirely the moment an appeal is formally filed and accepted by an appellate court. This middle tier of the judicial hierarchy does not merely resolve isolated disputes, it literally manufactures the rules of engagement for the future. When a panel of appellate judges publishes a formal written opinion, that document transforms into binding precedent. It becomes the unquestionable law of the land for every single judge operating within that specific geographic circuit. This is the awesome and terrifying power of case law. The appellate court possesses the supreme authority to hammer a permanent legal stake into the ground, explicitly defining what the federal government can and cannot do. A localized fire suddenly becomes a permanent scorched earth policy. Career litigators operating within the Department of Justice understand this dynamic implicitly. Their primary directive is not necessarily to win every single skirmish, but rather to fiercely protect the long-term institutional power of the executive branch. There is a deeply ingrained philosophy of strategic retreat among seasoned government attorneys. When they review a devastating loss at the trial level and recognize that their legal arguments are fundamentally flawed, they will purposefully refuse to file an appeal. They swallow their pride and walk away because they know that handing a terrible case to an appellate panel is the legal equivalent of handing a loaded weapon to an enemy. By accepting the isolated loss, they successfully prevent the creation of a permanent judicial ruling that would legally castrate the presidency for generations. This is precisely the devastating trap that the current political leadership is blindly marching into. The executive orders in question were not simply struck down. They were utterly humiliated by trial judges who recognized them as blatant overreaches of executive authority. The government lawyers analyzed the wreckage of those decisions and correctly concluded that an appellate court would not only agree with the lower judges, but would write a sweeping and comprehensive opinion detailing exactly why the president lacks this specific authority. That document would sit in the Federal Registry forever. Every future administration attempting to exercise similar powers would immediately run headfirst into this newly minted precedent. Opposing lawyers would cite it constantly. It would become an indestructible shield for private citizens against government overreach. Yet the political operatives dictating strategy from the White House operate on a completely different frequency. They are entirely consumed by the intoxicating theater of the daily news cycle and the insatiable demand of their political base to project an image of absolute dominance. They view the concept of a legal retreat not as a sophisticated preservation of power, but as a fatal display of public weakness. This profound political vanity has completely overridden basic legal survival instinct. By forcing the appellate lawyers to withdraw their strategic surrender and re-engage in a doomed legal battle, the administration is prioritizing a momentary headline over the permanent preservation of presidential authority. The irony surrounding this decision is thick enough to cut. An administration defined by its relentless pursuit of unchecked and absolute authority is currently forcing the judicial system to formally document and codify the absolute limitations of that very same authority. They are paying their own government lawyers to build a permanent constitutional cage around the Oval Office. When the appellate court inevitably issues its ruling, it will not just be a rejection of a specific policy, it will be a monumental restriction on the scope of executive power itself. The political leadership is effectively demanding that the courts write a comprehensive manual on how to defeat the president, and then they are demanding that this manual be distributed to every law firm in the nation. Consider the permanence of this action within the context of American history. When an appellate court establishes a binding rule, it is comparable to driving a massive iron spike into a solid wooden pillar. Future generations of legal scholars and administration lawyers might manage to eventually pry that spike out after decades of exhausting litigation, but the deep and gaping hole in the wood will remain forever. The structural integrity of the pillar is permanently compromised. A disastrous precedent functions in the exact same manner. It leaves a lasting scar on the jurisprudence of the nation, constantly weakening the foundation of the arguments the government can make in the future. The sheer malpractice of this political mandate is staggering to witness. The legal department had successfully executed the delicate maneuver required to dodge the bullet. They had successfully contained the blast radius of their own unconstitutional actions by attempting to drop the case. But the direct intervention from the chief executive acted as an order to actively dive back into the path of destruction. It is a fundamental misunderstanding of how power is actually wielded and maintained within a constitutional republic. True institutional power is often preserved by knowing precisely when to stay out of the courtroom. Furthermore, this reckless strategy forces judges who might normally be sympathetic to conservative interpretations of executive power into a corner. When presented with arguments that are fundamentally devoid of constitutional merit, even the most sympathetic appellate judges must rule against the government to preserve the integrity of the courts. The administration is essentially forcing friendly judicial figures to author opinions that will destroy executive initiatives. This friendly fire will create a body of law that strips the executive branch of its flexibility and its capacity to act unilaterally during future crises. This disastrous appellate strategy will undoubtedly be studied in law schools for decades as a premier example of political hubris destroying legal advantage. The lawyers forced to argue this case know they are walking into an ambush. They know they will face a panel of highly educated judges who will gleefully dismantle their hollow arguments and enshrine that destruction into binding law. The political base may cheer for the illusion of a fight today, but the permanent cost of that applause will be a severely weakened executive branch tomorrow. The trap was clearly marked, the alarms were loudly sounding, and yet the highest leadership deliberately ordered a full-speed advance directly into the abyss. The highest bench in the nation casts a long imposing shadow over this entire judicial spectacle. The recent shattering defeat regarding presidential tariffs serves as a glaring warning sign that the ideological loyalty the administration relies upon is rapidly evaporating. A 6-3 ruling against the executive branch is not merely a policy setback. It is a profound structural earthquake. It signals a definitive breaking point. The patience of the Chief Justice appears utterly exhausted. For years, there has been a prevailing assumption within the White House that appointing conservative jurists guarantees a protective shield against all legal challenges. That assumption is currently detonating in real time. Justices who consider themselves strict constructionists possess a deep reverence for the separation of powers. They do not view their lifetime appointments as mandates to serve as personal legal fixers for the executive office. When forced to choose between preserving the institutional legitimacy of the court and authorizing blatantly unconstitutional power grabs, they are increasingly choosing the former. The tariff defeat proves that the highest court will not contort the law to accommodate political tantrums. Wild speculation often fills the vacuum left by logical strategy. Whispers circulate suggesting quiet back-channel coordination between sympathetic justices and the executive branch. Some theorize that a shadow network is intentionally drawing these cases upward to establish favorable new rules. This conspiratorial thinking fundamentally misreads the current temperature of the judiciary. Supreme Court justices do not need to place secret phone calls to signal their judicial philosophies. Their written opinions broadcast their boundaries with crystal clarity. The administration simply refuses to read the signals. Expecting the very same justices who just publicly rebuked the president over trade policies to suddenly reverse course and bless the extortion of private defense attorneys requires a profound detachment from reality. The executive branch is steering directly into a massive collision with a judiciary that it mistakenly believes it owns. The loyalty demanded by the administration is entirely transactional, yet the architecture of the courts is designed to be permanent and independent. This fundamental clash of worldviews is precisely why the legal apparatus is fracturing. The White House operates under the delusion that raw political power can strong-arm the High Court into submission. Meanwhile, the justices observing the chaos from their elevated positions are silently sharpening their legal knives. They recognize that validating these chaotic impulsive directives would fundamentally compromise the rule of law. The arrogance required to believe the judicial branch will universally validate any action simply because of shared ideological roots is staggering. Every time the administration pushes a legally bankrupt argument up the judicial ladder, it forces the conservative majority to publicly draw a line in the sand. This is not a sustainable legal strategy. It is judicial suicide. By continually testing the absolute limits of authority, the White House is inadvertently forcing the creation of boundaries that did not previously exist. The Chief Justice has spent his entire tenure meticulously attempting to preserve the nonpartisan reputation of the court. He will not sacrifice his historical legacy to sanitize the messy, vindictive political maneuvers of the current administration. The realization that the highest court is no longer a guaranteed safe haven is sending shockwaves through the political leadership, fundamentally altering the balance of power. The facade of an untouchable legal fortress has completely dissolved. What remains is a crumbling institution actively drowning in its own contradictory mandates. A functioning federal department requires stability and strategic foresight to execute the law effectively. Instead, the current apparatus operates strictly on erratic impulses dictated by political rage. By constantly forcing career prosecutors to defend the indefensible, the administration is rapidly accelerating its own institutional decay. Every forced reversal and every failed vindictive investigation chips away at the foundational credibility required to govern effectively. The impending collision with the appellate courts will not merely yield another temporary headline. It threatens to permanently rewrite the boundaries of executive authority, creating a lasting judicial cage constructed entirely by the hubris of the very people trying to expand that power. The historical record is currently being drafted in real time by an administration that fundamentally confuses loud defiance with actual legal strength. When the dust finally settles in these federal courtrooms, the lasting legacy will not be one of absolute dominance but rather a masterclass in catastrophic self-sabotage. The machinery of justice cannot function as a personal weapon without eventually tearing itself apart. The legal and political landscapes are shifting violently beneath our feet. We are committed to dissecting these monumental courtroom battles and exposing the hidden strategies driving the chaos. If you found this breakdown insightful, please subscribe to United States News Daily. We rely on your support to keep uncovering the truth behind the spin. Share this analysis across your social media feeds and send it directly to your friends and family so they can understand the massive stakes involved in these upcoming rulings. We also want to hear your personal read on this developing disaster. Drop your thoughts down in the comment section below and let us know exactly how you see this unprecedented legal meltdown ending.